All
It's always
attendees
like a
are
million
in
things recording, so
listen-only
I
mode.
never really know if it's even working. All right, so I think I am recording and online, and I got my Facebook friends here. So let me jump into it. Good evening. My name is Brad Micklin. I'm the attorney and managing member of the McCallum Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues. Our office is in Nutley and Montclair, New Jersey. Today is March 28, 2019. I am broadcasting this from New Jersey, so those of you watching it at any other time or in any other location, you do need to make sure that it still applies, or even it does apply in your jurisdiction. Today's webinar is my monthly seminars that I do usually the last Thursday of each month. I'm broadcasting it simultaneously on Facebook, and I will also be posting this onto other social media. I am not posting it on YouTube and Twitter like I normally do because it's just too complicated. I'd rather put the PowerPoint up later. With that being said, let's jump into some of the material real quickly. Today's webinar is the 7 common mistakes men make when getting divorced. And yes, this is men. As I said, we concentrate on men's and fathers' rights. In many other seminars that I do, when they focus on men's rights, I often say that the issues also apply to women in most circumstances. This doesn't necessarily. The issues I'm speaking about are going to be more tailored towards men and men's issues inside of divorcing. But it's always helpful to have an understanding of what your adversary is going to be going through, or your soon-to-be ex-husband if you happen to be watching this and you're not a man. All right, so let's go quickly to me, my favorite topic. This is me. For those of you not have worked with me in the past, I am the managing member of the McCallum Group. I am licensed in New Jersey. I used to be licensed in PA, but I retired. The reason I only do New Jersey and I only do men's and fathers' rights in divorce and family law issues is I quickly learned when I was a young attorney that you can't be good at everything. So I quickly gave up most things and concentrated my practice. Founded the McCallum Group in 2001. I had done commercial complex litigation before that and a judicial clerkship before that. And I've been on my own since 2001. I started as a general practice attorney and then quickly concentrated into divorce and family law. As I said, we focus on men's and fathers' rights. I've had a number of women ask for us to represent them, and I don't turn women away. I'm not that mean. I'm always here to help people. I do say and believe that knowing and having a focus on one side of a case does give you a better understanding of what they're looking for. All of our documents are prepared that way, our protocols. So it gives us an advantage because we know what men are looking for and what men's issues will be. So I do try to help both sides of a case, but we do concentrate on men's and fathers' rights, and this webinar will do so almost entirely. Quickly, I'm just throwing up a slide of some of the awards I've been fortunate to receive in the past. These are also on my website because the ethics committee requires that you put selection criteria and a bunch of other things, but I don't put this up to try to impress people. I put it up so that you have a sense of my background and experience and that you can trust in the work that I'm doing. I have been fortunate enough to have a good deal of experience and recipient of these and many other awards actually too, but they're all on my website for you if you're ever curious. I'm going to actually take a second and explain the protocol for this. Also going to try to attach to the little chat panel that you have the PowerPoint. Okay, so can't do it because it's in use. Makes sense. But in most cases, the PowerPoint that I use has a lot of citations and case law references that are helpful. This one I don't think is going to have so much so that you're not going to be really at any disadvantage by not having it. But I will try to upload it afterwards. So the format of this is 60 minutes, give or take. I never limit myself. I do time it, but I never limit myself. I try to keep it as close to 60 minutes as possible, just out of respect for your time and I do like to leave some time at the end for questions and answers, so I stay on. People that are watching on Facebook, I'm not sure if you can post a question on the screen or not, but you certainly can message me, which I'll check before I sign off just to see if there's anything that you're interested in knowing about this topic. It's a one-way communication, obviously. I can speak out to you but not hear any comments, even though you have a chat panel with a microphone. Hopefully you can hear me. I'm going to ask those that have signed on to the webinar just to post in the chat screen on your right. You have a chat panel towards the bottom of the right, and just type in the portion that says questions. Just say that you can hear me, or that you can see the PowerPoint, so that I know the production is going forward correctly. I'm assuming people on Facebook can hear me because it's Facebook and it's an iPad, so it's less sophisticated. Fewer things to mess up. All right, good. So it looks like we are online, being seen and heard. So let's start jumping into the 7 common mistakes. I should have called it deadly mistakes, but it was a little overkill. So let's talk about the first one. First one is every other weekend dad. And the reason I call it that is your traditional parenting plan. And one of the main reasons that I concentrated my practice in men's and fathers' rights, and that was only over the past couple of years, is because the laws have changed significantly with men's and fathers' rights, but the attitudes have not. Not only of wives and female partners, but also in the judges that have been sitting on the bench for decades when the old laws and attitudes existed. And when I say every other weekend dad, that was customarily what a father would get for parenting time. Every other weekend, Friday to Sunday, maybe Monday morning, if he was lucky. And they kind of just accepted that. That was the way it was. And to go beyond that, like getting custody or even more parenting time, was almost unheard of. That's not the case. So one of the things I want to start going through is some of the issues around that. So first is the custody statute that will become relevant when you're seeking more than the traditional overnights, whether it's parenting time or custody that you're seeking. New Jersey statute annotated 9:2-4. That will outline, I think it's like 10 or 15 different criteria that the courts will look at when determining custody. It's good to be familiar with it. Don't go overboard, because there's a process, I'll talk about it a little bit throughout this webinar, that the court will put you through for parenting time issues and custody issues. And the factors only become relevant at the very conclusion of that entire process. So up until that point, it's really more important to learn about the process than the law itself. The statute is gender neutral. It does not favor women as custodial parents. Most decisions for children will be governed by what's called the best interest standard. If you are involved in any kind of custody-related matter, you obviously heard this over and over again. It is the standard that will govern all kinds of custody decisions. It's a little nebulous because there's nothing that really says best interest. But the one point I do give to my clients is it's the best interest of the child. And while that may seem axiomatic or obvious, people don't realize that. When they make custody arguments, they're often arguing things like it's more convenient for me, or there's family support to help me with parenting time or babysitting, or I'll be happier because I'm making more money. None of that has anything to do with the child. And that's a mistake I think a lot of people make. The statute does have a presumption in favor of frequent and continuing contact. Now, that's not as generous as it sounds. The statute presumes as much time as possible. Now, it does not say equal. There was a move recently to have a statute passed that created equal custody, physical custody, as a presumption. It didn't survive, but at least shows the trend that our state is moving. And it also opened up a lot of the eyes of judges who are now considering that issue as a starting point, even though it's not the actual law. Now, in order to get that, though, you will be forced to go through the process. In a nutshell, when you file for custody, and I've done webinars on custody itself, so I won't go too deeply into it here, but the custody process will take you about a year you will have at least one expert as a joint expert or maybe your own. So be prepared if you're going for the frequent and continuing contact, equal parenting time or custody. Just be ready for that issue. I'm not, like I said, that's not part of this webinar, but it is important to know. So let's talk a little more about being an every other weekend dad. There is something on the books called the Tender Years Doctrine. It was considered the standard for a very, very long time, and only recently have we seen it erode. And that basically stated that a child of tender years, and that would usually be 3 or 4 and below, was best suited to be with his or her mother. It was just the basic starting point, which is why it made it very challenging for fathers to have anything more than this other weekend schedule. But now, like I said, statute does promote equal rights for both parents. Now, the problem with that is mothers are still commonly awarded custody because they're still more commonly the parent who provides the most care for children. I say to a lot of my clients, things haven't changed as much as people want to believe, and a lot of people are offended by that, but it's true, at least in the work that I do and the clients that I see. Women still stay home more often than men as caregivers. They still are more the primary parent for caregiving in an intact family. Now, that's not good or bad, but it's just the way that it is. So you need to realize that if you're coming from that kind of an arrangement, you may have problems getting the equal time or even more time than the alternating weekend. So you want to try to change that circumstance before you actually file for divorce. So if you have a stay-at-home spouse and you're able to, with either financial reasons for daycare, the children old enough, have your spouse get to work, it's going to be a very important point that I would recommend. And I normally tell my clients to try to do so. Big issue will be your work schedule. Courts have to be pragmatic about custody issues. If you work in New York and you leave your house at 6 in the morning and you get home at 7:38, and your spouse, your wife, the mother, is a teacher who goes and comes on the same schedule as the children, you're not likely to get custody. Now, I'm not saying that you're going to get the other weekend either, but you're not likely to get a lot of weekday parenting time because your schedule doesn't allow for it, and there'd be no reason to take the child away if the mother is going to be home at that time. Now, I mentioned a moment ago, so I'm going to talk a little bit about the process, but only as far as the mediation, which is the first step a court will send you through when there's a true custody issue. I think the court rules talk about a genuine custody issue, but they consider any issue anytime you file to be a genuine issue. So if you file, you go to mediation. It is a court-sponsored program. You don't pay for it. It's confidential. You also don't need to sign or agree to anything if you don't want to. They will give you a proposed agreement afterwards. You can always have your attorneys review it and advise you. You can add and change it, or you can reject it entirely. I got to say, I'm not a big fan of the process, and if anybody from the court system is watching this at any point in time, they're going to be upset. But in my experience, the mediators are very traditional. And I don't mean that in the sense that they just give you your alternating weekend, but that is kind of where they start from. Alternating weekend, your traditional alternating holidays, some time in the summer, and your birthday and Father's Day. They don't really look outside of the box. I think it's partly because they're old-fashioned, partly because there's a great volume to the program. Mediation can be effective. It can be effective in the courthouse, don't get me wrong, depending on the level of conflict and how much you're really looking for. But if you have a high conflict case or complicated issue or children with special needs, special or unique needs, I would recommend maybe a private mediation session as opposed to going through the courthouse. Indicate in the very beginning of this process how much custody that you are seeking. Custody and parenting time. I sometimes use the words interchangeably, but more often than not, I'm talking about parenting time, because parenting time dictates more of your rights than the custody terms you will have in most cases. But you don't want it to look like you've changed your direction or your desire for any reason other than you think is best for your children. So it's best to be clear in the beginning and assert that so judges are aware at the onset. All right, so a little bit more on this every other weekend dad because it is significant. Now, the next slide is talking about not discussing anything about your case with your children. And that is my starting point of advice. Now, if judges are listening to this part, they're also going to be upset with what I'm going to say next, and that is that may not always be possible. First of all, children pick up a lot more than parents realize. They see the mail that comes into the house. They hear the telephone calls. They hear the conversations at parenting exchanges. They have a sense of what's going on. Sometimes you have to discuss some of it to help them understand what's happening. The simple bright line rule that everybody gives you about not talking to your children sometimes is not in their best interest. Also, when there are, let's call them alienation efforts by the other parent, you need to undo that damage. Now, you have to tread carefully because, one, it can be damaging to your children. It can also affect your case. If the court finds out that you're talking to your children in a negative way or about the mother, that will impact negatively your chance of getting as much custody as you may otherwise be entitled to. The next slide is talking about promoting a relationship with the child's mother. And I know in some cases that's challenging. I know in some cases that's impossible. And you'll know whether or not that is the case. But you need to try your best because no matter what the court documents say, no matter how your custody rights are determined, your relationship with your children is going to be severely impacted by the relationship you have with their mother. First, they're going to model their relationships off of your relationships. So you want to be the best role model you can. But also, usually one person is going to have more control in the situation. They may either be the parent of primary residence, they may have more parenting time. So even though you might have a custody decision that says joint legal custody, which means each of you should share in decisions, if you have somebody who's just looking to interfere in your relationship, they're going to make a lot of decisions on your own, and the courts can't micromanage and punish them for that. So the best route, if possible, is to keep good relationships and communication. That's always not. Another tip is going back to what I said before, that the attitudes haven't changed when I spoke of judges and wives and mothers. And also you'll see that with a lot of attorneys. You'll find surprisingly a lot of attorneys, men and women, that still believe that a mother should be raising the child and that a father shouldn't be making a claim if he is not better suited to provide daily care for their children. And it just shows the sort of bias that's been plaguing men for so long that led me to change my practice in the way that I have. You need to find out in the beginning and jump ship. I want to give a quick hello. I've seen a lot of other people signing on to my Facebook. Appreciate the support. Love seeing everybody. I never say specifically hello to anybody, and I say this every time I'm on. So if you're on a lot, you hear a lot, and I'm sorry, but I never want to compromise anybody's privacy because not everybody can see everybody else. I think only friends of the same friends can see that you're online. So love the support. Love seeing everybody. I'll get back to my PowerPoint. Oh, also, I take this, I guess, because new people signed on too to Facebook. If you're interested in the PowerPoint, one, it'll be on my website and it'll be on YouTube in a week or two. But you can jump right now onto my website, click onto the webinar link and get onto the live version and get the PowerPoint if you're interested, because the angle is different. This is more like a podcast. But if you like this, great, hang out. And let me get back to this. So let's move on to principle number 2. And principle number 2 is standing on principle. And this is more of a practical point. And I'm just going to say, as an attorney who deals with men's and fathers' rights, men are often very stubborn. And they'll say things like, I'd rather pay you than her. And that never makes any sense. I'll be the first one to say, I'd rather you pay her than me, as long as the numbers make sense. So, you'll get people spending thousands and thousands of dollars over a very small issue. The popular one is legal fees. And I'll tell my clients right off the bat, don't expect to get legal fees. If you do, great, you're ahead of the game, but it's not likely. And the cost of fighting for the extra legal fees is probably going to outweigh the legal fee you would get, even when the court rules say you're supposed to get legal fees. And there are cases. Courts will routinely not give you all of your legal fees. They'll give you a portion of it. And you've incurred more trying to get that one. What I always say to people, especially when you're looking at like a high conflict divorce, is this is your children's college account. And you really want to be mindful in the beginning of where this case is going to go and what the likely outcome is. Is your investment going to really net you a benefit with your children? Is it going to give you extra time? Or is it going to drain you financially into such an extent where you now can't spend as much time because you have bills you got to pay? It's really something you got to balance. It's a challenging issue for a lot of people. And not more often than not, but often they get so embroiled into the fight that they lose sight of what's going on. And that's why I call it standing on principle. You will learn one way or another that 97% of all cases settle. And I don't mean just all divorce cases. I mean custody, civil lawsuits, personal injury, criminal. 97% of those cases settle. Of the 3% that go to trial, at least 2/3 of those settle trial, which means your case is likely to settle despite your belief that many have that's not going to happen. Even of the 1% that go all the way to trial, if they don't resolve by the end of the case, that 1% of cases have an 85% chance of returning back to court for post-judgment issues, which means fighting for things after your case is over. And that's essentially because somebody else made the decision for you. You put the life of your children and the future of your relationship in somebody else's hand that didn't know enough about your situation and made a decision that you or the mother are not happy about. It's not a wise choice. Now, I have to admit, I do have a larger number of trials, but because of the nature of work I do, I have more contested matters and more difficult parties. And I'm not saying necessarily my clients. It could be on either side. I've had difficult clients, I'll admit it, that I can't get reason through. But I've had just as many, if not more, difficult adversaries who force it to trial. So we can and do go to trial, but it's really not your best bet. You want to try to avoid it as much as you can because you just don't know what the judge is going to focus on. Now, along with those lines, you'll find that the court system is designed for settlement. Everybody thinks divorces are high conflict and they're all big fights and everything's battled in court, and at the end they pull out the smoking gun that proves like the one parent is bad and that they win custody. It's not like that. The whole process in anything in family law, whether it's custody, divorces, other than domestic violence is an exception to what I'm about to say, but everything in the process, the court will send you through a number of settlement processes. Almost all supported by the court, almost all paid for by the court in some way or another, except maybe one, because they want you to settle. They want you to give you every opportunity to do so. And going through all the settlement will do a number of things. First, it helps you narrow issues. You'll have, depending on your case, anywhere from 2 to 10 different settlement conferences. You may settle some issues at some of them and others at others, but each time you get closer and closer, hopefully, to resolution. Also, and probably more importantly, you get to hear objective opinions from other attorneys, sometimes even other judges that aren't involved in your case because they're the parties helping you with your mediations. So it's nice to hear from somebody who has no horse in the race what your case looks like and what your outcome may be. It's very hard. It's impossible, I think, for parties to do so. And I think it's challenging for lawyers to be as objective because our job is to advocate for our clients. And if you care about your client, it's hard to be completely objective because you want to help them get what they want. And that's what they're coming to you for. And judges don't want to. They'll fight you tooth and nail to have you settle your case and not go to a trial. They don't like trials. They will spend more time trying to get you to settle than the trial itself would even take. I don't quite understand the logic behind that, but there's something going on in the courthouses that I'm not fully aware of. I think it's their administrative offices demand that they move a certain amount of cases and that they not have certain trials or certain appeals. I think although their job is tenured, that they can be moved to different locations that they don't like. So I think they have to keep their numbers moving for that very reason. It's just a hypothesis. Whatever the reason is, they will fight you tooth and nail. Just because they tell you got a trial date, it's not a trial date. And the worst part can be, you think, and it's always on a Monday. You'll get a trial date. You'll go on Monday with your lawyer and your exhibits and your witnesses, and the judge tells you to sit out in the hallway because they got 5 other things on. You come back after lunch. They tell you to sit out in the hallway. Then they tell you to come back another time. And again, it's always on a Monday, so you spend the whole weekend preparing. You go in and you go through the same thing again. If you're lucky and they start taking testimony, they'll usually take an hour or two of testimony, and then they'll tell you to come back after lunch, or they'll break for the day and tell you to come back again. So any trial can take months and months to complete, regardless of the simplicity of the issues or complexity of the issues. I had simple custody decisions. I had simple divorce cases that could have been tried in 4 or 5 hours, take 4 or 5 months because they just won't give you the time. And it's not just because they don't want to give you trials, like I said a moment ago. I mean, that's a large part of it, but they also have a lot of cases. They have a huge caseload. They need to move. So you'll go on, and even though nothing was originally scheduled that day, by the time you get there, there's 10 things that got scheduled or an emergency that comes up that they have to address. All right, so principle number 3, my favorite. People taking, and remember, this is about mistakes in divorces, taking legal advice from friends and family. I probably should have put in here the internet too, which is ironic because everything I'm doing right now is on the internet, but I still tell people to watch it. But avoid ever taking advice from friends and family. I mean, there's countless reasons. First of all, everybody's life is different and everybody's divorce is different. You could have the exact same fact pattern, the same judge, the same county, the same lawyers even. Your case is still going to go different. So what was helpful to them isn't necessarily going to be helpful to you. I always recommend hiring a matrimonial attorney, not because I am one, but because there is a difference in people who specialize. And not every lawyer realizes that. I think a lot of general practice attorneys believe that they can handle family matters because they don't believe that they're that complicated, or they'll take a child support matter and they'll think it's not that complicated, and it is. The nuances to any legal matter is always very complicated, which is why I don't do every legal matter. There's no way to do and know everything well. So I always urge people against it. You don't have to hire me. I tell everybody that I meet with, look, you don't have to hire me, but please hire somebody. But also consult with a lot of attorneys and a lot of tax professionals. Your cases will always have financial issues, even if it's just a simple custody matter. You want to have advice from a tax professional as well as several attorneys so that you get well-rounded advice. Another thing that's not on the slide, but something I often find myself telling people about, is when you hear from friends and families too, you hear the horror stories. And I always make the comparison to the McDonald's lawsuit that anybody of, 40, 50 years old will remember. Like 20 years ago, some woman spilled coffee and got like $3 million. And everybody thinks, now if I spill coffee, that's great, I'm going to get $3 million. And it's not the case. The reason why we all know that case, even 20 years later, is because it's the aberration. It's the strange case that makes the news. It's the weird and unique case that people talk about. So when you get a friend or family telling you about a divorce, especially one that they heard about, not even their own, they're telling you about the strange or unique case that they heard about, or the hell that they went through that has nothing to do with your case. And you can't judge from the horror stories, because that's the small portion of divorce cases. People think divorce and custody is all, throw down bloody battles, and they're not. The majority are not. There's a handful that are, and those are the ones you hear about, and they're the most challenging. But don't go in expecting that, because that's not necessarily going to be your case. But if it is, you'll know right away. Now, my next one, this one was the one I like the most. The next one is the one I hate the most. Failing to respond to your lawyer. Now, this happens for a lot of reasons. First, people are busy. Second, lawyers are expensive. Third, nobody's happy to be in the middle of this. So you have all these forces working against responding to your attorney. I know my clients hate when they see my name on an email, or they panic when they see my caller ID, but it's important. If you don't, it can often lead to defaults, meaning you lost your right to answer, sanctions, attorney's fees for delay, and adverse decisions in your case. Now, I'm giving the kind of heavy-handed position to this because it is very important. If you have a lawyer, you're paying that person for a very good reason. You need to respond. You only make your case worse. Take deadlines, very important. Get your documents together and be very, very thorough. Take the time. You will always have a number of very tedious documents to fill out, especially in a divorce, even in a custody case, but especially in a divorce. You'll fill out things like case information statements, interrogatories, which are written questions. They are challenging. But if you don't start and do them right away and get them to your lawyer, you will be losing not only your rights in the court, but you'll be prejudicing your positions when you actually, if you do have to go to a trial. Along those lines, I want to talk about a couple of the documents you're going to talk about. Like I mentioned, the case information statement. This is probably the single most important document you'll have in a divorce case and even in a custody case, but less so in a custody case. Case information statement, for those that haven't had to fill one out, it's a very long, tedious document about the financial aspects of your life. It covers everything from how much you earn and pay in taxes to what you spend on hair care every month. Now, what I tell my clients is it needs to be accurate, but not perfect. So don't agonize over trying to figure out how much you spent on toiletries in the month and not send your papers back to me in time. Estimate it. Make a best estimate that you can. Look at your bills and then send it to me, and we'll go through it. Now, if you have also an experienced lawyer, we can usually have some sense of whether or not your numbers are right or wrong. A common error, for instance. And as an aside, I did a webinar on case information statements, what to include and exclude, which if you have to do a case information statement, very helpful to watch. But there's common errors that people make, like when we add up all their expenses, it's more than their take-home income. Now, that may be made up for with credit cards and family loans, but if not, there's a discrepancy and it needs to be resolved. But work diligently on things like your case information statement so that you don't have the issues. Providing the information when requested will significantly improve your case and save you a ton of money. I tell almost every client that I meet with when I sit down that legal fees depend largely on two issues: how good they are with paperwork, three issues: how good they are with paperwork, how reasonable their two parties are, and how much time I spend in court. An example I give to people is if I send you a document by email and I have to ask for it back and I don't get it back and I have to email again or call to get it back, and then I get it back and it's half completed and I got to follow up to get it filled out, you've paid 3 times for what would be one charge. You just tripled your bill. And that's outside of my control because I need to get the information. And it's not just me. You're going to be like that in anybody. And again, part of it's because people are trying to avoid it. Part of it's because they're busy. But if you make our job harder, it costs you more, and then you lose your ability to really see things through. Moving on to number 5. And I say this all the time, and it's amazing how many people just aren't able to follow this advice. Be careful with written messages. This should actually say be careful with any message. Just as bad that people write ridiculous emails, they also leave stupid voicemails. I tell my clients, imagine that a judge is going to be listening or reading whatever it is that you're writing as a guide to everything that you do, because it's very likely that he or she will. So first, be careful what you put on social media pages. Careful where you're checking into. Careful what your picture like. You know, if you're at a football game with your young children and you're drinking beer, it may only be a beer, but that picture is going to come back to haunt you. You cannot take down adverse information from social media. It's like destroying evidence. And there is a maintained version of it online that people are often unaware of. So if you wouldn't want a judge to see it, don't post it. Careful, like I was saying a moment ago, what you put into writing. That means text messages and emails. They can all be reproduced easily. We know it. You can take a screenshot. You can forward it. You can download it. We all know it's very easy to do, so don't do it. I know it's easy to get wrapped up in this kind of exchange, but you got to remember what I keep saying, and that is somebody, and likely a judge, is going to be reading it, and it's going to really hurt your case. Don't send messages about what the children are saying. Don't send messages to the children about the litigation. As I mentioned before, my caveat earlier was if you need to undo damage, you may need to involve your children, but don't do it in a writing or a text message, which is obviously writing, but don't let it be discoverable. Now, also, a lot of people aren't aware of this, but in New Jersey, you can record any conversation that you're a party to, and without telling the other person. So I always tell my clients, one, assume that you are being recorded when you're talking to people, and two, record every conversation you have with your adverse party in case you need it. And I don't mean keep them, because sometimes you're recording a meaningless conversation, but record every conversation in a high conflict case, in a custody case, a disputed custody case, because you may need it. If there's nothing meaningful, then you delete it. If it is helpful, you store it somewhere. And there's a million different ways to do it. There's a million phone apps. Recording a conversation is simple. But remember, you have to be part of the conversation. I can't stress that enough. If you are not part of the conversation, it's a violation of state and federal law. You can get in a lot of trouble. So as long as you're part of it, you can do it. Number 6, and this is an issue, obviously, that representing men come up a lot. Assuming that fault is relevant. So let's talk about that for a little bit. New Jersey is a no-fault jurisdiction when it comes to divorce. That means, well, I shouldn't say that. I guess it's technically not entirely accurate, but we're as close to being no fault without saying no fault as you can be. The simplest reason to get divorced is using what's called irreconcilable differences, which says, I've been married 6 months, we have differences and breakdown in our marriage, and we're not going to reconcile. And it's lasted 6 months, and we're not going to reconcile. So basically, if you're married for at least 6 months, you can get divorced without having to prove anything. Even if you use the other reasons to get divorced, like extreme mental and physical cruelty, abandonment, sexual deviant behavior, drug addiction, all these horrible things that may be very significant to you, doesn't change the outcome of your divorce. And it won't change the outcome of most custody cases, believe it or not, either. But this is more relevant to divorces. But fault also impacts custody a lot less than people think. Unless there's drug use, obviously that's going to be significant. But a parent's bad conduct doesn't impact their ability to be a good parent in most cases, in most judges' views, depending, of course, what the conduct is. But don't go in thinking it's going to make a significant difference. The next one, which is very hard for people to swallow, is that adultery and marital misconduct is not relevant almost ever in a divorce. There's some limited reasons. One, if the paramour, the other party, the other adult is in some way a risk of danger to the child. They might have a DCP past, Division of Child Placement, usually previously DIFUS. If they're violent, obviously, then it would impact custody, but that has nothing to do with adultery. It has to do with the person's mannerism. Equitable distribution, which is the distribution of assets and debts in a divorce, is generally not impacted by adultery unless there's a significant change in the structure of your assets and debts because of the relationship. Like somebody ran up a ton of debt because they were taking a girlfriend on vacations. That's going to impact equitable distribution. But other than examples like that, you're not going to find many reasons why it actually does. Now, part of my office specialty is dealing with narcissists. If you've been to my websites and my YouTube page, you'll see I do a significant amount of work on that. And I say that not because it's relevant to the 7 mistakes, but on number 7, enabling bad behavior is something that's very common in the circumstance. So, well, let me just give you like a side point, because I don't think that I actually mentioned this too much in this provision here. But people believe that other people act like they act. So if you're a reasonable person, you expect people to be reasonable in response. So you'll be generous and expect generosity in return. So if you get an unreasonable parent making an unreasonable demand about parenting time or custody or even your divorce, a lot of people will try to concede a point or give up something or not enforce a custody violation because they figure if they'll just cooperate this time, they'll get cooperation in the future. But if you're dealing with a difficult person or a narcissist or an alienator, what you're actually doing is reinforcing the bad behavior, because it's just like, and I hate to say it, it's like animals. If they do something bad and they're rewarded for it, they learn that it's an effective approach, they'll do it again. So you will effectively be training that person to interfere with your custody rights or to take unreasonable positions. Now, specifically, let's look at a couple examples like that I commonly see. One is having your spouse stay at home, not working, long after the children are grown and in school. Now, I'm not saying that it's a bad thing if that's what you want to do, but if you have financial issues or custody disputes, then you shouldn't be doing it. And that's more often the cases I see, because financial issues are one of the greatest causes to divorces and custody disputes. And a lot of people will have a spouse stay home, especially in North Jersey, where it's extremely expensive and they can't make it work. They do it for so long that it jeopardizes their ability to get equal custody, and also ends up spending money and time on claims like alimony and larger child support awards. Now, if your spouse is not working, there will be what's called imputed income, which is the court will determine where or what your spouse could be making if she was working, and add that into your support analysis. It's generally small. It's usually much smaller than they might actually make if they were out. And that will, in return, cause you to pay higher amounts of support for longer. Enabling bad spending habits, another issue. Letting them rack up credit cards, getting expensive cars that you can't afford. Everything in this kind of a situation is divided probably equally. Now, I say equally, even though the statute does say equitable. The starting point is equal. And that means the court has to find a compelling reason that it should not be equal. And that is very rare. Now, if there's discrepancy in income, if there's no children, these are reasons why you might have an unequal distribution of assets and debts, dissipation of assets, things like that. But generally speaking, you want to go in there and assume it's going to be 50%, just like legal fees. Go in assuming it's going to be 50%. Structure your case around it so if you do better, you're ahead of the game. And kind of in summary to this point about the bad behavior, the theory that I have is people always want to reconsider bad decisions that they made after they get divorced. They'll say things to me like, I wanted my wife to work for 20 years, but she refused. I didn't want my wife to spend, and I say wife because it's men and the father's right, so don't get offended. I'm not saying that it's only women, but I'm representing men, so just we got that caveat out there. They'll say things that, I wanted to get a cheaper car. She insisted. That doesn't work in a divorce court. The divorce judge will say that you made the decision together. Whether it was an actual decision or you just acquiesced and remained silent, the decision that you made was not getting divorced earlier. So if you stayed and your spouse didn't work, you acquiesced to that. And you can't now reconsider it because it was a bad decision. It's going to be equal from where you are. And that's why you may end up supporting a spouse that cheats on you and commits adultery, because you stayed married. That is the end. I'm going to quickly say hello to some people that just signed on. I love seeing everybody here. I don't see any questions here. I'm not really sure if you can post questions or not. I'm going to leave my chat panel on the webinar open. Actually, I'm going to quickly check to see if there are any questions that you're posting. I got to apologize too. I usually tell you at the beginning to save your questions and post them until the end. So I'll stay online here for a minute to see if there's any questions that you might have. I will check into my Facebook Messenger in case anybody that's online wants to send me a message and doesn't want to do it on the screen. All right, I'm not seeing anything. I'm not going to stay too long because in my experience, if you don't have a question up here now, you're probably not going to have one. Everybody on Facebook can call me, email me, messenger me, so anything comes up, I'm certainly here to answer any questions you have. Love seeing everybody. Hope everyone has a good night. I will actually probably be online tomorrow. I think I have it set for 3 o'clock, but I'm not sure. I'll post it. I got to be also, I'm going to be in New York tomorrow on Fox Business News at like 5 or 6. Anybody who's going to be up, say hello. And that's why I'm not sure if I'm going to be online or not, because I'll probably be getting back and my whole schedule's going to be messed up. But hopefully I'll see everybody tomorrow. And if I don't for some reason, have a great weekend. I'm going to sign off here and on Facebook. Good night, everyone.